Your Honor. Dorsey Carson on behalf of the bigger platform. I think it's important to note from the outset two things that may be, that you may have a mistaken impression on based on those arguments that were just made. First of all, the assumption that Mississippi Power Company competes in this 23-county region. They have a monopoly, and that in itself distinguishes the Central Bell case, where that was after the split up of Ma Bell, and that case even says that they're even competing with AT&T. And so that, I think that the case is mentioned, besides that not being a Supreme Court case and a Court of Appeals, which we'll talk about that, I think that case can be distinguished on that. The Caldwell case is even more easily distinguished in the fact that that it was a competitor seeking the information. And that's typical. Your Honor knows I do a lot of construction law, government bidding work. That's standard when a competitor to a bid process asks for that information. It's standard that that's protected against the competitors if it involves confidential information. So the bid laws are not applicable here in that respect. What is applicable is the statutory language of 7923.1, and there are exceptions to disclosure, public disclosure, only in limited circumstances. The Mississippi Supreme Court has said that any exceptions need to be applied very strictly, and disclosure is liberally applied. So the interest is in public disclosure. Here we have a plant that is going to raise rates in these 23 counties. And I'll walk through some of that with you, but that's relevant because 7923.1 specifically, expressly in this statute says, nothing herein shall be construed to deny access to such information submitted to a regulatory agency by a public utility that is related to the establishment of or changes in rates regulated by such agency. This plant, no doubt, has an effect on taxpayers. The brief that we submitted today gives you 3 examples of that. There are numerous others. The third example we gave, Your Honor, was a statement that was submitted to the commission. It was filed confidential initially, and then they removed an objection. So in that document that was later released, it showed that there was going to be $59 to $61 cumulative impact per month per ratepayer. Okay. So for some of these ratepayers, we could even be talking about 100% or even more increase in the rates. This is exactly why 7923.1 has that provision in there. And the problem with all of these documents is, first of all, they have to prove that they own it. And then they got to prove that they've taken efforts to maintain its confidentiality, that they have intentionally tried to keep this out of public realm. Natural gas rates are not private. They're not proprietary. They're not confidential. The federal government, in fact, the Energy Information Administration, publishes these rates all the time. They do forecasts. There's experts all over the nation that do this. This will have no impact on any supplier setting rates or not setting rates based on that. All this information is public. All of it is easily accessible on the internet even. To the extent that Mississippi Power says that it's confidential, I would say that they have waived that. They have not protected it because they have taken certain steps to release certain parts of it. And in our response, we also attach a letter from MPC's attorney. In that letter, Mississippi Business Journal had asked for information on rate effects to retail customers and wholesale customers. The response letter that's attached, first of all, notes that the information is old, which I think is also a relevant factor here. This was all submitted in 2009. And this is a letter from counsel for MPC. I would point out that the more recent rate impact information was provided publicly, And in graphical form, on page 12 of the Phase 2 direct testimony of Ms. Frances Turnage, filed December 7, 2009, and that the rate impacts have been reported in various publications in Mississippi at various times. So they're saying you can go find this information, just not here. So they haven't taken efforts to protect or hold this information confidential. One of the requests that we have is related to the company, the Energy Ventures, which itself publishes these rates online. The other portion of that is that I mentioned earlier, they have to actually own it. I've seen nothing, and I don't think anything's been submitted that shows that their employment of this third party means that they have maintained any proprietary rights to this information. And I would be surprised to see that. And that was Gannett Publishing versus Energy. In that case, the Supreme Court laid out some black letter law on there about how ratepayers have the right to access this public information. And I heard somewhere in Mr. Pettis' argument that that if it goes to the media is a competitor. Well, Gannett says exactly the opposite. It says that any member of the media has right to this just as a ratepayer would have under the circumstances. So it's not looking at it from a competition standpoint. It's looking at it from a public disclosure to the ratepayer standpoint. In this case, they held information confidential, but they held it because, and they're very specific about this, that Energy had a private contract with Nissan that did not affect the ratepayers, did not affect the customers, did not affect the public. On the trade secrets, again, the burden is on Mississippi Power Company to prove that it's a trade secret. There's nothing in what Mr. Pettis just said that indicates to me that it's a trade secret. He said there's a performance data report that predicts cost. Again, a prediction is not a trade secret. The statute, the applicable statute in Mississippi that defines that is found in 75-26-3. And trade secret there means information including a formula, pattern, compilation, program, device, method, technique, or process that one derives independent economic value, actual or potential, for not being generally known, which we had already discussed, and not being readily ascertainable by proper means, which I also discussed, where they said you can find it elsewhere.
I didn't understand.
Are y'all media?
Yes, sir.
Well, what y'all gonna do with the document?
Well, I'll tell you what we think they're going to show. And what we think they're going to show is that Mississippi Power, whether it be intentional or accidental, that they forecast natural gas projections well above what they should have been, so that they could justify building a $2.4 billion plant that's now a $2.88 billion plant. And we think the taxpayers and the ratepayers in this district, according to the statute and according to equity and all the public policy arguments that are available under public disclosure, that the public has a right to know that. What fuel prices were they projecting to justify this? Because since that time, we think it's not going to match up with the other publicly available information. We think it's probably not going to match up with the federal numbers.
I assume it does. What does that get you?
It may not get us anything. We don't know, but that's not the standard. That's not the point of the open disclosure. Yeah, it may not have any value, but we don't think it has any economic value to any competitor, which is the standard here, or one of the standards here.
Anything else?
Does Your Honor have any more questions?
Well, right now, that's it.
Okay. Then for right now, I'm done. Thank you, Your Honor.